Sé que teníamos todas muchas ganas de vernos, de tener unos minutos para poder...
I know we are all excited to meet each other, to talk a little bit, but we have to move to the next roundtable, which is about labor jurisdiction. The only one to introduce herself here is me, because my colleagues are well known by you, I think. My apologies to her because I asked them a short CV for them. A short CV is 5-6 pages, so I can't read them. I'll make a short introduction, and as Theta said before, if anyone's interested in those brilliant CVs, we may send them to you. So first, let's begin with Maria Luisa Segovia. She's a magistrate of the Labor Division of the Supreme Court in Spain since 2006. This may not seem very surprising, but let's not forget that the first woman to be present in the Supreme Court in Spain entered in 2002. I think you are the fifth woman in the Supreme Court. Only 5 women out of 76 positions. So this means a lot of your professional career. So she's a magistrate of the Supreme Court, and she will tell us her vision of the Supreme Court jurisprudence on issues regarding gender perspective. You have the floor, María Luisa.
Pues muy buenos días a todos y todas las asistentes. Mi agradecimiento.
Good morning to you all. Thank you and congratulations.
El estar aquí, asistir a conferencia, a los debates que tienen lugar y mi alegría por compartir mesa con tan estupendas compañeras. Mi intervención, como es muy breve, porque no puede ser de otra manera, va a tener 3 puntos. Una consideración sobre qué es juzgar con perspectiva de género, una mirada sobre los artículos que nos permiten aplicar la perspectiva de género y un breve comentario sobre las sentencias que la jurisdicción social ha dictado aplicando la perspectiva de género y aquellas otras en las que, a mi modo de ver, debió aplicarla y no se aplicó. ¿Qué es juzgar con perspectiva de género? Juzgar con perspectiva de género quiere decir juzgar con ausencia total de discriminación, tanto en el lenguaje como en los motivos como en la fase declarativa o resolución. Y no es fácil a veces ver la discriminación porque llevamos...
There is discrimination because our background, patriarchy, doesn't allow us to assess if there's actually, if this situation takes place or not. Judging with a gender perspective means that our decisions should be used to detect if there's any sort of discrimination that we didn't notice. That at a larger level and at a smaller level, we should analyze in detail everything which is said there. Let's not forget that we are sons of and daughters of our culture and nature, and this drags us to situations which are not very positive for this. Our culture, our background is Roman, Greek and Roman culture. The most patriarchal on earth. And who's the king of the jungle? The lion. The situation of female lions is very sad. Female lions hunt, kill the animal, and once they killed it, the male lion comes and begins to eat. So our background, both for nature and culture, are not very positive for women. This is why we must keep pushing with this gender perspective in all our judgments and decisions, not in a punctual way. We have to do this consistently. Let's not forget that judging with a gender perspective, this shouldn't be done only by women judges. Any judge, whether a man or a woman, should apply this gender perspective in all his or her decisions. Let's not forget that sometimes it's very easy to see where there is discrimination, because whether it's very clear, the pay gap, having different wages for men and for women, we can detect that very easily. But there are other occasions where there are indirect discriminations, more difficult to see, and it's there where we have to be alert to realize that there is such a discrimination. Do we have precepts in our code that allow us to apply this gender perspective? For us, it's essential to have specific articles that allow us to implement this philosophy or this way of judging with a gender perspective. We begin, as usual, with the Constitution. Section 14 doesn't allow discrimination based on gender. It's Article 9. Constitution says that public powers will promote conditions so that equality and freedom of individuals and groups will be actual, real, effective, and will remove any obstacles that go against this spirit. There is an organic law for the effective equality between men and women from 2007. This organic law has one goal, which is achieving full equality between men and women, removing any kind of discrimination to the woman, no matter the background or circumstances, in working environment, cultural environment, civil environment, trying to achieve a more democratic, fair, and equitable society. When judging specific articles that can be used, which are they? I think within this organic law of effective equality between men and women from 2007, we have two important precepts: Article 15 and Article 4. Article 15 says that equal treatment and equal opportunities between men and women is a transversal principle that has to be respected by public authorities. The judicial power is a power as such, and we should act taking into account this principle for equality between men and women. Article 4 says that equal treatment and equal opportunities between men and women is part of the legal order and should be applied when interpreting and implementing law. This means that when we interpret and we implement any law, we have to think about gender equality, equal treatment, and equal opportunities. This means that we have to achieve real, effective equality. And for that, we need to take a step further. We have to make use of positive actions, balanced presence, and equal opportunities for that. How have we applied these precepts? How has social jurisdiction applied these precepts? So I'd like to say that there's a dissenting vote of a judge in the Canary Islands, a matter where a maid is sanctioned because the company says that she didn't clean 2 rooms. But the dissenting vote says that this woman shouldn't be sanctioned because here there is multiple discrimination due to gender and age. Why due to gender? Because maid is a sector of occupation which is absolutely represented by women. 98% of people working in this sector are women. So it's a sector which is worst paid and with worst demands regarding performance. So here it said that she's forced to clean some rooms. It's supposed that she has 19 minutes to clean up every room. And the company says, no, I've measured time and it's clear that we can do it this way. I took 4 maids, they began to work and in 4 minutes they could clean this room. But let's see what's the age of these maids. Second, what time did they begin to work? Early in the morning, or were they working during 7 hours in a row? These are elements that have to be taken into account to assess performance. So a gender perspective in this situation would allow, given this dissenting vote, this woman should have not been sanctioned. Another decision from my division of the Supreme Court where gender perspective was not applied. And in my view, it should have been applied. It's a judgment regarding a hotel, Melia Hotel, with great economic results, absolutely great. And at a given moment, they decide 2 hotels here in Madrid, next to the airport. The company sees that the hotel is not full some days. There are no guests. But of course, I have to pay the same money, the same amount, the same wage to the maids. So they said it can't be that way. So they outsource the service. They outsource with another company the cleaning of the rooms. And all these women are fired. 19 women and 1 man. You are no longer necessary because we have 1 company that will do the cleaning and I will pay them for every room cleaned. I will pay 6.5 euros. What's the consequence? First of all these women are fired, women who are maids. Secondly, the new maids coming with a new company earn much less because they are paid on the basis of every room cleaned. This finally caused a strong movement by maids because they realized that they were mistreated in a labor sense. So they began to get organized and they could determine that in the collective agreements, even though the service was provided by an outsourced company, the wage should be the same as it was before. So I think that gender perspective should have been taken into account in order not to allow that this service should be outsourced, just to optimize work. Can we optimize up to the point that performance should be the maximum and not a reasonable one for a hotel? And if we finally admit that it can be outsourced, why do we outsource only maids and not the bar, where mainly men work there? This perspective, as I say, was not applied here, and the situation was admitted. And as I run out of time, thank you to the moderator. Thank you.
Muchísimas gracias, María Luisa. Sé que luego...
Thank you very much. I imagine there will be questions for you later on. So you will be able to elaborate a little bit more about the judgments that you didn't mention. And now about discrimination at work, let's talk about pay gap. For that, we have Katrin Semaikova. I don't know if I pronounced it correctly. After being a lawyer for many years, she's a judge of the Constitutional Court of the Czech Republic. Your country is one of the most affected countries in Europe for this situation. So, as a specialist, she will tell us about how's the situation in Czech Republic. Thank you.
Thank you. Ladies and gentlemen, I prepared the word dear ladies, but I can see men, so ladies and gentlemen, I greatly appreciate this opportunity to speak at the meeting of women judges, and I consider it an honor to share with you the Czech experience with the topic of gender pay gap. This topic is very important as the Czech Republic is one of the 3 worst countries in the EU in this respect. I'm going to reflect briefly on the reasons of this situation and to consider possible changes. Whenever there is a talk of the inequality of pay for women and men, I recall the comparison that Ruth Rubio Marin used in her lecture in 2016. She pointed out that a manager of a bankrupt British bank had held his job in this bank for consulting on restructuring the bank he had brought to bankruptcy. For this, he received a monthly salary in the amount that a childminder with 20 years of experience would have received for 3.5 years of work. This is, for me, a description of the structural differences in the employment and of and pay for men and women in a nutshell. As I have already said, according to the Eurostat data from 2017, the Czech Republic has the second highest difference in the earnings of men and women in the European Union. It is 21.1% compared to the EU average of 16%. There is only Estonia in front of the Czech Republic, while Germany is right behind the Czech Republic. Then, if we purify data, that is, when we compare earnings in the same position with the same education level achieved and the duration of practice, then this difference in Germany will drop to 4%, but in the Czech Republic it still ranges from 11 to 13%. There has been a threefold denial in our debate about the existing gender pay inequalities. Firstly, the very existence of gender inequality is denied. People refuse to believe that there is really a difference of 21% in pay and say that it is wrongly calculated. The second denial is that when the existence of inequality is admitted, the Czechs do not perceive it as something problematic and unjust, but either as natural or as a result of the free choice of women. And the third denial is that the potential problem of gender inequality should not be addressed by changing regulation or a state policy, but by the activity and change of life priorities of those women who point to such inequality. It is possible to ask what influence of 40 years of communist regime in Czechoslovakia had on the position of women in the Czech Republic, whether the egalitarian state socialism was also egalitarian in the field of gender issues. In the legal and political documents of the then regime, we can find the equality of men and women highlighted in the public and labor spheres, but not in the domestic sphere. However, in real power structures, women did not actually exist. There was not even one female leader among communist leaders. Women were represented in parliaments on a quota basis, but parliaments did not really decide anything in communist regime. The most powerful was the Bureau of the Central Committee of the Communist Party, which was full of men. In the 50s of last century, the socialist regime forced de facto all women to work, usually full-time. However, the socialism did not do anything about private inequality, and women thus remained the main household carers and childminders. Thus, Czechoslovak women carried a double burden at work and at home. For women in the West in the 50s, to work was actually a great freedom. For Czechoslovak women, the ability to relax for a while constituted a freedom. At a time when women in Western Europe and the United States complained of frustration stemming from limited life opportunities at the beginning of the 60s, women in Eastern Europe were simply overworked and exhausted. Thanks to two shifts, one at home and one at work, they did not reach any higher positions at work, and they did boring work both at home and at work. In both spheres, private and public, they served men. And what are the current causes of differences in wages and salaries for men and women in my country, in the Czech Republic? The causes are numerous and are linked by many factors. The phenomenon of unequal pay for men and women is very complex. Above all, the following causes are indisputable. First and foremost, non-transparent systems of remuneration and career advancements at work have an impact on gender pay gap. Another cause is the low level of reconciliation of work, private life, and family life. In the Czech Republic, the lack of childcare facilities, both for preschool and school children, is particularly important, while a too long parental leave and low father's care contribute to the situation as well. The persons caring for children or seniors in their families are threatened by the low percentage of quality flexible forms of work in the labor market. Another role is played by the so-called horizontal gender segregation of the labor market. In the sectors dominated by women, salaries are lower. For example, this concerns nurses or teachers. The skills, knowledge, and competencies are not appreciated in women, while the same are overestimated in men. Of course, this is connected with the vertical gender segregation of the labor market, that it is unbalanced representation of men and women in leadership and decision-making positions, or the extremely low representation of women, known as the glass ceiling, and the majority representation of men, known as the class elevator, and in the decision-making positions. Gender stereotypes form the roles of women and men in the family and the labor market, influence the choice of education and profession, and of course are linked to the greater social and financial appreciation of the so-called male professions compared to the so-called female professions. And again, the connection with the low involvement of men in family care needs to be mentioned. And by the way, paradoxically enough, men with children earn on average more than childless men. All the assistance of the Czech state, which should make life easier for women, usually leads to the worsening of their situation in the labor market. The entitlement to a 4-year parental leave for each child, in fact, excludes the large number of women from the labor market. The difference in their career and therefore in their pay is never made up afterwards. And the parental allowance, which by far does not reach the amount of the previous salary of a woman, only supports the family strategy that women stay at home throughout the parental leave. Basically, it is the exchange of 4 years paid by the state for a lifetime low salary and consequently a low retirement pension. An attempt to legally enshrine the obligatory offer of kindergartens for 2-year-olds has failed, and parents thus cannot find a financial affordable childcare option for their children of up to 3 or 4 years. Overall, it results in that so-called penalization of maternity in the Czech Republic is one of the highest in relation to work earnings. So why on average do Czech women have lower earnings than men? In my opinion, it has 3 main reasons. The prejudice that leads employers to pay lower salaries to women is comparison to men for the same job. However, it is not just the prejudice of employers, but perhaps even of the affected women. With the lower push from women, the usual practice is that if you do not demand a higher salary, the employer will simply not give it to you. Why would the employer do that? Also, according to my experience of employer and lawyer, women tend to demand an increase in their salary less often and less convincingly than men. Another reason that leads to lower earnings of women is that the jobs sought by women are less paid than male jobs. Is it either because the positions are mostly occupied by women or because the jobs are less prestigious and that is why women are there? Probably it does not make sense to hold this debate that is basically about which comes first, the chicken or the egg. The third reason, statistically significantly lowering the general average earnings of women, is that within a hierarchical structure, a man is usually a higher rank and therefore has a higher salary than a woman. In order of the situation to change, I think it is now necessary to change the approach to promoting the family life in the Czech Republic and to put more emphasis on that raising children and caring for other family members is not responsibility of only women, but also of their partners. The whole society should help. It is also important to promote the career advancement of women in order to disrupt the traditional stereotype that only men can be the leaders in business and government structures. There is a need to show examples of women with a high status and in high earnings positions, thus disrupting stereotyping views on the role of women in family and in society. I'm pleased to have the opportunity to create, jointly with all the women judges present, a supportive environment for women who seek to change the stereotypes described above in their important judge positions. Thank you for this extraordinary opportunity.
Muchas gracias, Caterina.
Thank you, Caterina. Now, to talk to us about one of the issues mentioned by Caterina, the subject of the pay gap, we have one of the greatest specialists in this country, perhaps of the whole of Europe, Maria Emilia Casas Bahamonde. When we talk about her, she was one of the pioneers in this country. She was the first chair of the Constitutional Court and, for the moment, the only. So we hope that this changes in the future. Maria Emilia is going to talk to us about working hours and work-life balance. Thank you. Good afternoon already to all of you. It's a very great satisfaction to me to be involved in this important conference organised by the Spanish Association of Women Judges. I would like to thank Gloria Poyatos in particular for inviting me to join you all here. I celebrate her energy and her dynamic attitude. It's very important for all of us, not just as this event important for women, but in order to create truly democratic society, these events are important. I'm very pleased as well to be on this panel with friends and colleagues, and also have friends in the audience and honourable colleagues. I'm going to talk about time. Time is life. I'd like to talk about how time is different for women compared to men. If we talk about the care sector, which has been traditionally the responsibility of women and underwent considerable change when women, not in small numbers, but in large numbers, just like at the end of the last century, the middle and the end of last century, when these women went back to the labour market. They had paid jobs. We have always worked, but we have gone from having a reproductive, domestic job, sometimes called unproductive. Well, women went from that role to taking on paid jobs with the limitations, obviously, of each country's economy and cycles of prosperity and recession. But regardless of prosperity, there was always a negative reaction to the incorporation of women, in that we are lower in terms of occupation, active population. We tend to work in feminized areas of employment. As Caterina said, this is one of the causes of the pay gap. And as a result of that decisive change, the fact that half of the human race could return to work, this, well, meant that time was devoted or distributed differently in the lives of these women. So how did this take place? So if we're talking about a woman, she takes on a paid job. She no longer purely devotes her time to the tasks of caring for others. And this caring activity can be considered as an organized activity within the market, which appears to be growing as a result of the aging of society. And on the other hand, we have the involuntary care activity or caring activity carried out mainly by women who devote their time to family and domestic tasks, working with their children or with the older members of the family in our societies. Obviously, the situation in Europe is very different to other parts of the world. In Europe, we are a highly aged population. In other parts of the world, there are much higher birth rates than we have here in Europe. But nonetheless, we're talking about a huge burden of work for women who take on this role. 2/3 of this involuntary, unpaid work falls upon women, and it's growing. And 22%, over 22%, but well, more or less, 22% in the hands of children, mainly girls, young girls. According to the ILO, according to the data for a report that I'm going to mention on the future of work in the world, as a result of on the event of its 100th anniversary. It was created in 1919, and for the 100th anniversary of the ILO, they've gathered information about the state of work in the world, and they have highlighted this fact, which is about, or shows the inequality between men and women. So if we talk about our time, the time we have during our life, this lifetime is different for men. The traditional person in charge of the legal system, above all in labor law, which was constructed upon the idea of adult men with a short life expectancy and low training. This has been broken up over the years, and the prototype that is behind labour law is forcing the seams of the system, let's say. But the patriarchal society referred to by Maria Luisa Segovia is governed by capitalism, economic organization of society. That economic organization of society coincides with the positive law, the Napoleonic system, and the invisible hand of the market of Adam Smith, which organizes the economy upon the economic man and never the economic woman. So this coincides in the idea that the man is the beneficiary of the legal system in all areas of activity. The right to work has great importance when we talk about equality, because equality begins in the home, just as we could say for inequality. In the home, sex is the factor which leads to the division of tasks. And this can be seen in the world of work as well. We have a discrimination against women. As a result of that discrimination, women are limited or in political life, in social life, and in cultural life. So we could talk about the legal system with the inclusion of women in a formal way, represented in the Spanish Constitution by Article 14. Every person is equal before the law, men and women. But we are not equal before the law because this is just a formal law which does not accept the gender perspective. It doesn't recognize any of the differences of women and the way their lives are structured. This formal, uniform constitution uses a standardized language. If we talk about the women's incorporation into the labour market, women are really invisible. Everybody's treated the same, the language is shared, but inequality persists. At a later stage, law develops towards positive action, which give a differentiated treatment on the basis of gender to women as a consequence of having suffered a different situation to men over the years. They've been in a relatively inferior situation with less opportunities. So in the 20th century, the end of the 20th century, we have such actions that we see which are more complex, positive equality actions. They are combined with democratic measures in the political bodies, with quota policies, which represent progress in the presence of women in the legal world, in economic relations, in political relations, and social relations. That development has gone from the labour market into the political world, and there is still a stronghold which is resistant to these policies of quotas. And here we're talking about the private business and economic powers, which still remains mainly in the hands of men, with different initiatives which haven't really taken hold in order to achieve real participation of the higher structures of businesses. But when the rules or the laws establish quotas, they do so stating that women will occupy non-executive board positions. We could talk about Simone de Beauvoir. Here, the man is always in the executive position. The woman is always in a secondary, non-executive position, leaving it up to those organizations whether the women should have executive roles or not. But without any legal intervention to open the path, it will be impossible if it's left up to pure recommendations. This is one of the failings of the organic law in Spain. The presence of women in the economic scope, in politics, in decision-making levels, our absence in those decision-making tiers of economic power is all due to the fact that the law is just a recommendation. The legislator really didn't, in doing that, really has no impact in reality. Having said that by way of introduction, I would like to focus my presentation and then very quickly make a final proposal. I've just been told that my time is limited, and I was going to refer to the appearance of social classes in the 19th, 20th century, which has been considered a lesser phenomenon, but it was in fact truly decisive. The proletariat and the incorporation of women into the labour market. We have seen a white male chauvinist attitude. That's important, but I shall leave that and come straight to something I want to put on the table, which is the idea of judging with gender perspective against the gender perspective. So we have to use the gender perspective in order to get a result which is opposite to gender perspective. This is what happens in the work-life balance and the distribution of time, or at least in Spain, in distributing time between work in the labour market and involuntary unpaid work that women carry out. There was a gender perspective in 2007 in the Constitutional Court, but not in 2011. But the court understood that it had to judge the use of those rights to make family time and personal time compatible with working hours, and to give this a gender perspective. When the rights were recognized, practically in the 21st, well, the end of the 20th century, start of the 21st century, those rights have been systematically used by women. So they are feminized rights. It's the women who ask to reduce their working day in order to be able to achieve a better balance and to look after their elderly or the children. It's women who ask to have time off from work to look after their children and the elderly. It's women who ask for their timetables to be adapted in order to carry out these tasks. And as a result, these rights have once again left women in this inferior position. Although we have to say that without those rights, the women would have had to completely abandon the labour market in certain occasions. So they are feminized rights, which worsen discrimination in certain situations. They are rights that have allowed women, however, to remain in the labour market, and that's the gender perspective. But the gender perspective appears when we talk about joint responsibility, when they are rights exercised equally by men and women. And to achieve this, we need two operations. First of all, the law governing the rights should be exactly the same for men and women. In Spain, we have seen recent progress, which has been important. And over time, it is working to give men the same paternity leave as women have in their maternity leave for when a baby is born. So the idea is for the leave to be equal for men as for women. So it's not special for women, apart from in the ones referring to the pregnancy, the childbirth, and breastfeeding specifically. Secondly, the judges need to understand joint responsibility. They need to understand what joint responsibility is within the freedom of men and women to find a work-life balance. In Spain, we've seen a phenomenon which I would like to highlight, which is really quite striking, based on the precept of the Organic Law on Effective Equality between Men and Women, Article 44 to be precise, which is called the rights to reconcile the working and private life. It says the reconciliation of working and private life will be, the right to do this will be recognized to men and women at work in such a way as to promote a balanced solution for family responsibilities, preventing any kind of discrimination in the implementation. So this is so anomalous that there are decisions by labour courts that when a woman applies for such measures, the judge states that if the man can manage to find that balance, then if they can do it, it's the man that should do it and not the woman. And they resolve this lawsuit saying no to the woman, and then the man doesn't ask for measures. So we're talking about something between the woman and the company. For example, I want a flexible timetable. I want to work fewer hours. I want to adapt my timetable. And the company says no. And the judge, instead of protecting the woman who wants to use her freedom to do so, he says, I'll apply the 44. What have you got? You've got a father-in-law, a sister-in-law. Have you got somebody in your family who is unemployed? And that's what happened in that court case. They asked for that proof. What does your husband do? Are you separated? Bring me the divorce sentence. Do you have any measures in place? And I'll tell you whether you can ask for these measures in your company to reconcile private and work life. This is judging poorly using a gender perspective. By saying that it should be the man who achieves that balance, you cannot refuse a woman's request, subjecting her to a violation of her fundamental right to privacy because she has asked for proof, something which is truly impossible. The company is not going to allow those measures unless the woman can prove that she has no possible alternative. Because if the woman asks for that, it's a problem for the company. And by consequence of that, it's not going to be allowed unless the judge can get absolutely an unbeatable proof. And even in that situation, they will say no. And if you can get a change in shift, then that's much better. So we're talking about feminized rights, but women can't use them, unfortunately, because of this idea of judging using a gender perspective, because of the idea that the man should do it. Well, that's great, but the man doesn't do it in the end, and it's the woman that suffers this limitation of her freedom when this gender perspective is applied poorly. I would like to finish with a proposal. What do you think what would you think if I said, and I say, that the right to work at the moment should be a global project for the construction of gender equality? What do you think? Do you think this could be the right way to work in order to create the legal structure for the 21st century? Shouldn't we have an understanding of equality as something that is not marginal? So this, that, and the other, as well as equality for women, the salary timetable and equality for women, different atypical ways of contracting and equality for women. Shouldn't equality be at the centre instead of at the end? Shouldn't it be at the centre of the construction of gender equality? So I would call upon the legislator. The moderator is looking at me very sternly, so I will have to finish. But I think we have to call upon judges to rationalise, to really understand what gender perspective is all about. Thank you.
Bueno, haciendo una aquí de mala.
Yes, I have a very tough role to play, and I'm sure you understand that I have to be quite strict. Now, the time is for Alia Garbi. Alia is a judge in a court of, in Tunisia. She is currently the chair of the civil chamber. I would like to thank her, Alia, because she had to replace or stand in for a colleague very last minute. She's had to prepare for this event in just a few days. And bearing in mind how busy all of us are in our everyday work, in our profession, I thank her for that. So Alia is going to talk to us about the glass ceiling and the specific case of her country, Tunisia.
Okay.
Bonjour tout le monde.
Good morning to you all. It's a pleasure for me to be with you today. My name is Alia Garbi, cantonal magistrate in Tunisia. My presentation will be around glass ceiling in the judicial system in Tunisia. Women liberation by women is one of the main accomplishments in my country, one of the main pillars in our modern society. This is because of different public policies and unavoidable developments that made Tunisia an example to follow by different countries, even the most developed ones. Since the independence up to the present, Tunisia has enacted different texts and enforced laws to achieve the effective gender equality and to promote the role of women and their active participation in different issues in the society. This approach has been a progressive one, but steady, supported by the educational level of Tunisian women that allowed them to be present in responsibility positions. Regarding statistics, in 2016, women represented 32% of the public administration and 56% of other positions. The public administration of social services. Public administration is one of the sectors where women are most present. Regarding sectorial discrimination, we see that there are more and more women working in these sectors. Women with responsibility positions came from 27% in 2010 to 33% in 2016. This progress cannot simulate a more complex reality that can be translated by the important lack of women in different positions in ministries and the lack of presence of women in senior positions like CEOs. The same happens with director positions, 12% for women, 16% for men. Service directors, 50% for women, 40% for men. This is a paradox with these figures. We talk about the glass ceiling, professional glass ceiling. There are invisible and indivisible obstacles for women to have access to positions of more responsibility. We insist on the fact that women should work at all levels: university, public function, artistic activities. The expression glass ceiling can be completed by the glass wall or glass corridor or glass premises. With that, we have a horizontal nature of professions. Men and women with the same level of education don't have the same job. So there are limitations, invisible limitations, but they are powerful, however, on the professional careers of women regarding certain sectors of employment when this glass ceiling limits the access to certain positions. It's like a glass cage. The public administration, which is more feminized, also has these situations where there is a glass ceiling. Although there are many women, there's a glass ceiling. Now let's talk about the historic perspective of Tunisian legal system and judicial system. Then we will see statistics, problems and challenges. But now, historic approach. In 1968, the first women judge was appointed in Tunisia. This shows how women could have access from then to certain positions. In 1985, there were more law graduates, and hence there were more women who had access to judicial positions, judge positions. In the last few years, we see an increase of women's presence at the first judicial level, both for administrative, criminal, or financial justice. Statistics show that the amount of women in our system is 38% of the total of judges. This is a proportion which keeps growing since the revolution in 2011. In this regard, the presence of women in the judicial system is indispensable. Here you have 3 charts. There are statistics. The first shows the increase of the percentage of women judges between 2011 and 18. The second shows the proportion of women in the 3 jurisdictional orders: judicial, administrative, and financial. And the last one this shows the percentage of women judges. There is a political feminism, it's true, but let's not forget that gender equality in this domain is not absolute, mainly given how judicial responsibilities are granted. Of course, there's a higher presence of women in the judicial system, but there is a glass ceiling, and they cannot access senior positions. And although this Enlightenment era, there are several obstacles. A general one for all public servants: maternity leaves, its impact on the seniority degree, depending on the age. Some women don't request to be promoted because that entails more responsibility, for instance, instruction judges. Other obstacles related to security. The nature of our profession implies a certain degree of security, criminal security. This means that women's situation may be complicated, but there are different initiatives to fix this. Legal initiatives regarding organic laws, for instance, the law by the Constitutional Court, and in other laws regarding the status of lawyers, of judges. We recommend to take measures to improve the level of women's presence at in all the branches of the judicial system. The strategic vision of the justice reform for these 4 years is being used to prepare a new strategic document, and there we are advocating for adding this gender perspective. We have to adopt a sectorial plan to integrate gender perspective in the law, because guaranteeing the presence of women is not only a goal, it is an indispensable measure to have a sustainable judicial system that represents not only the equality and non-discrimination prerogatives, but also diversity in the roles imposed. Thank you for your attention.
Muchas gracias. Muchas gracias, Alia. Me alegro no haber tenido que emplear esa cara.
I'm glad not to have to be too stern that time and use my fierce face. So thank you for sticking to the time. Now we're going to hear from Muriel Robinson, She comes from the Labour Court in Scotland. She tried to explain the legal system, legal structure in her country to me. It's rather complicated. But now she's going to talk about her specialty area. She's written articles. Some of them have been translated into Spanish, in case anybody is interested, which is about positive action. Muriel, you have the floor.
Thank you very much. Well, I'd like to just start by saying how very pleased I am to be in Spain while UK is still in the European Union. And hopefully that might remain the case. But I'll perhaps just leave that there. So my topic is on positive action. And as Maria Emilia has said, that positive action is often a controversial subject. It's controversial because it's often mistaken for positive discrimination. And it's controversial because it does involve preferential treatment of women or of minorities, but only in certain limited circumstances. So only where there is underrepresentation or underprivilege or disadvantage because of past or present discrimination. And I think that there's really no need for me to put up slides of statistics to show that women in almost all parts of the world, in almost all walks of life, of course, are disadvantaged in some way. So positive action is essentially about moving away from equal treatment, moving away from the situation where individuals are treated the same to a focus on equality of outcomes or results. This slide, I think, illustrates the point. It's from the United States, as you might realise, and I think, however, we should perhaps find a European example, but more particularly one with girls in it, perhaps, to illustrate the problem here, or the issue here, which is about basically those blocks required to be put in place if we are to ultimately achieve equality for women. Now, positive action of sorts has had a long history. In the United States, we've seen affirmative action, largely as a response to race discrimination. In India, reservations were introduced to address caste discrimination. And in the European Union, there were legal provisions very early on to permit positive action. Most recently, the Norwegian example, where there was the use of quotas to increase representation of women on company boards. And this received much publicity, largely because of its significant success, moving from 10% in 2003 to 40% in 2012. And I should just mention that that includes executive as well as non-executive positions. With regard to the current EU law, the provisions are to be found in the Treaty of the Functioning of the European Union, Article 157, which permits positive action. We see that Article 23 of the Charter of Fundamental Rights does not disallow positive action. And specifically for gender equality, we look to Article 3 of the recast Gender Directive, and you'll see there the language used: with a view to securing full equality in practice, the principle of equal treatment shall not prevent specific measures to prevent or compensate for disadvantages. Now, I think it's interesting to reflect at this point that there was a proposal, for a European directive, I think encouraged particularly by the Norwegian experience. The proposal was for a directive to move towards or improve gender balance on company boards. But you can see that it was blocked by, in fact, 10 member states. So that has not become law. And I think that this does illustrate the resistance that Maria Emilia has mentioned in her talk. Now, there are a range of types of positive action that can be taken, and that range goes from what we call or have been described as an absolute preference. So that might be where there are quotas, for example, where there are places reserved for women, and that goes through to a weak preference, where, for example, gender might be a criterion for a particular appointment, but it would be equally weighted with other criteria for that appointment. It's important to note, however, that these different forms of positive action are not necessarily permitted by the European Union. There are limits to the laws, and I think these are well illustrated by a couple of cases in the employment context. The first one to come before the European Court of Justice was the Kalanka case. That was a case in 1995. It involved German regional law, and it was related to the situation where there was a tie-break in favour of equally qualified male and female candidates. And in such a situation, the female, if there was underrepresentation, would get the appointment. It was an absolute automatic situation where there were two candidates equally qualified. And the European Court of Justice said that went too far in being absolute, giving an absolute right in that way. However, only 2 years later, in the Marshall case, 1997, again about this time German national law, in that particular case, in a tie-break situation, women would be favoured, but there was a savings clause. There was a clause which would allow for deserving men to be appointed if their individual circumstances supported that. And so we're talking there about those with disabilities, perhaps single fathers, those perhaps long-term unemployed. That savings clause was crucial because there was no absolute unconditional right for the woman to get the job in circumstances where women were underrepresented, and the European Court of Justice said that that was permitted. And that essentially now summarises the current position of the law. So long as there is no absolute and unconditional preference for women, then positive action measures will be permitted. Turning to the British law on positive action, we've had positive action measures in the UK since 1975. The Sex Discrimination Act in particular allowed for positive action measures in the employment context. That was expanded in the more recent 2010 overarching Equality Act to go beyond the employment context, so allowing for special measures in circumstances where women and people with other protected characteristics were underrepresented or disadvantaged. It also introduced the tie-break provisions in recruitment and promotion context, essentially to mirror the limits of European law. That certainly was the intention to include in British law, going as far as it was possible to go to comply with European law. The British law, as with the European law, is, however, voluntary. There's no obligation to introduce positive action. And in the most recent example, where it has shown to be problematic, because I've done some research in this area, which shows that it is that employers and others are very reluctant to do positive action when it is voluntary in the way that it is. And a recent case just in 2019 in the UK relating to attempts by the police to increase diversity among their ranks was successfully challenged by a white heterosexual male. So you can understand then why the reluctance if there's going to be challenges from the majorities, because the law is not as prescriptive as it might be. But we have got some good examples from the UK. The UK contingent will perhaps recognise this, this picture from 1997. It's the British Prime Minister, Tony Blair, surrounded by a very large new intake of women in the British Parliament, which was the result of positive action measures, in particular women-only shortlists. Women-only shortlists were, however, challenged in the courts. However, it was too late, as you can see, because lots of women got in into Parliament, the British Parliament, through women-only shortlists. It was challenged, but because Labour was then in power, they were able to pass a specific act, the Sex Discrimination Election Candidates Act, to make sure that women-only shortlists, other methods of positive action to get more women into the Westminster Parliament in London, as well as the Scottish Parliament in Edinburgh and the Welsh Parliament in Cardiff. So there was some success there. I was involved in doing research for a train drivers union, because they were very keen to encourage the rail companies, the train companies, to take on more women, there being very, very small numbers of women train drivers. It did turn out that the real problem was the trade union members themselves, who were putting quite a lot of obstacles in the way of encouraging more women to apply. I did note that although we had women pilots in the Second World War, this union, ASLEF, refused to allow women to drive trains in the Second World War. So you can see what I was up against there. We have had some particular initiatives, very important initiatives from our Judicial Appointments Commission. And because they're in something of a privileged position, they were able to make amendments to the relevant British laws for appointing the judiciary, and so that they were able to introduce specific provisions in relation to tie-break situations, the equal merit provision, in order to, in circumstances where men and women and where other minorities were equally well qualified, then the underrepresented group would be allowed to be promoted. And then finally, because I just wanted to highlight a Scottish-specific initiative, because Scotland is another country and we do things differently there. We have the Gender Representation on Public Boards Scotland Act of 2018, which is an attempt to reach 50-50 men and women on all public boards, non-executive positions, it has to be said, by the 31st of December 2022. So this is a specific initiative that has not been replicated in the rest of the UK. So I think while positive action remains voluntary, I think you can see that these initiatives are very, very valuable in making some progress towards achieving full equality in practice for women sooner rather than later. Thank you.
Thank you very much, Maria. Ahora ya por
Now, lastly, but equally important, this is the cherry on the cake that we've baked between all of us. We have Susana Medina with us. She is the Deputy Chair of the Tribunal, the Superior Court of Justice of Entre Rios, and President of the Argentinian Association of Women Judges. She was the President of the International Association of Women Judges until recently. So, with that double experience, she's going to talk to us about the importance of associations in the judiciary with a gender perspective, particularly with reference to Argentinian jurisprudence. Thank you. You have the floor. Good afternoon. First of all, I would like to thank the Spanish government, the Committee for Equality in the General Council of the Judicial Power of Spain, the Association of Women Judges of Spain, and Dr. Gloria Poyatos as their representative. It's an honor for me to be here with you, with a considerable group of Argentinians. I haven't had a chance to say hello to them all, so my dear colleagues, good afternoon to all of you. More women. More women. More women, more justice. And so why more women, more justice? I'm going to reflect upon the importance of judicial associations with gender perspective. Why? If we hadn't had an association of women judges, men always ask us, why an association of women judges? Well, because of everything we've seen so far. Maria Luisa explained what it is to judge with gender perspective. Katerina from the Czech Republic talked about the pay gap, the glass lift, and the need for a supportive environment for this battle that they are carrying out in the Czech Republic. Maria Emilia talked wonderfully about time, the time that men and women devote to work and to caring for our families. She said that judges need to know what joint responsibility means. What is a work-life balance? And she talked of a project to construct a gender equal society. Aria talked about the glass wall and the glass cage in the judiciary. And Muriel from Scotland talked about positive action that can be carried out to change our reality, the reality of all societies, all countries, all economies. Absolutely all societies, as I said. And this is not something new. Violence, discrimination, abuse, harassment, none of this is new. That's why the International Association of Women Judges appeared 28 years ago. or was created. Here I can see many young people, new people to the association. We have representatives of 35 countries who are coming to a conference for the first time. And I would just like to briefly tell you how and why this began. The Convention for the Elimination of Discrimination Against Women had its 10th anniversary. It was approved in 1979. On that same date, an association of judges had been created in the United States. So both were celebrating their 10th anniversary. There wasn't the same communication that we have today via internet. So the American judges decided to invite 50 judges, female judges from around the world, to see how well the convention was working, this convention for the elimination of all kinds of discrimination. Letters were handwritten back then, written with pens, and they took months to get to their destination. So the American judges wanted to know what was going on with gender-based violence, discrimination, and inequality. 50 judges got together over 2 days, and they saw the power of women to change the world. We were and we are convinced that we are a powerful force which can change the reality which affects and causes suffering among many women all around the world. The association was formed in San Diego in California in 1981. And following on from that, we began to begin a path in all of the different countries, and this is the result. 28 years ago, nobody talked about these subjects. There was no gender jurisprudence, there was no gender perspective doctrine. And this was not something individual. We worked as an association. And through the work of the association, we have reverted the situation in many places. The first training program of the IAWG was for jurisprudence based on equality. We did this in Argentina, and we took it to different Latin American countries to study the international documents on human rights because the judges, male and female judges, were unfamiliar with this. We had to show them the law, and we all learned something new. And that's when the change began to take place around the whole world. I would like to just mention our founder, Carmen Ajuay. She was the founder of the International Association as well. Women who had to face discrimination, abuse, disloyalty, betrayal, even from their own colleagues. But the result is this wonderful movement, which is judicial associations with a gender perspective. In my country, for example, when Carmen Ajuay and Elena reached the Supreme Court of the nation, rather than giving up on what they had been working on over the last 20 years or so, they took positive action. They created the Office for Women in order to work from within the judicial power to change the mentality, the mindset of the civil servants, of the people working there, to change their approach to gender issues. And they created the Office for Domestic Violence in order to help domestic violence victims, which until that time had been left unattended. That's when we saw the big change, the revolution in the judicial power in Argentina, where we also have shadows. It is not all full of light. There we have 57% women, but only 27% reach the higher positions of authority in the hierarchy. And there are difficulties for women to get to the higher positions within the hierarchy. But it's true that we have progressed a lot. And we also have, however, the glass ceiling or the glass cage or the glass lift. But Agustina O'Donnell, a colleague, talks about the straw ceiling. She says that it's the straw ceiling, which isn't even made of glass, which is a ceiling which is cheap, but won't let us access the legal professions because judicial associations has to intervene in legislative powers, executive powers. In the councils, we need judicial associations and the association movement to go further and to continue working to defend the rights of women. In Argentina, we have grown as well, and we have helped other powers, such as the legislative power, with the regulations. As judges, as women judges, we help the legislators, male and female, to approve the law on the overall protection of women, for example. We help to ensure the inclusion of femicide in the criminal code. And lastly, we have insisted, together with our colleagues, our members, to approve the Micaela law, which obliges all of the people in the state powers, both public and private, to undertake training on the gender perspective. From now on, no judge, no business person, no legislator will be able to pretend that they're a little bit absent-minded or distracted when it comes to gender perspective. And that's something we have achieved in our association. There is a judge, a colleague of ours, Alberto Domenech from Cordoba, a very well-known expert, who says that we need more sentences with gender perspective. This is true, we need more. Because we are we as judges, we are the ones who can change this reality. And to achieve symmetrical situations of power. And the law is not enough on its own. It doesn't guarantee anything on its own. The law is just one step. And the judges are the real protagonists. The judges should and must interpret the law with a gender perspective. And this enables us to really do our job correctly, and it's through training and forums such as this that we can learn to do that. But we don't just need judges with legal expertise. There's a book, El Alma de la Toga, written by a Spaniard, which says the rights are in the books. Some people may look at them and study them and be at peace. But what life demands is not written anywhere. And today, life demands that the judges, men and women, take greater protagonism. And they can't do that on their own. And that's why we have our associations. Associations of male and female judges with a gender perspective. The reality changed 28 years ago, but for the worse. if we look at what's going on around the world, in Bangladesh, an 18-year-old girl who reported her teacher for harassing her, she was burnt alive. And at school, even her schoolmates were involved. They took part. And after 4 days of agony in the public hospital, she died. That behaviour is what the International Association of Women Judges calls sextortion. And we have a programme called Sextortion. Vanessa Ruiz, the current chair, managed to include that behaviour, that action, as an anti-ethical action. And here we have the representative of Greece, Saida, and we were together in that. What's happening in Afghanistan, where parents sell their daughters for early marriage for $3,500? What about Iran, where they have just convicted and confirmed the sentence of an activist lawyer who defended women who chose not to use the veil? She's been imprisoned to 144 whippings and 33 years in prison. What about Turkey? In Turkey, where women are suffering growing harassment when it comes to taking a free choice with regards to what clothes they wish to wear. They are being relegated from public spheres when they do not dress the way the government wants or the religion wants. And Nigeria, in northwest Nigeria, this must be one of the worst places to be born a woman. Girls are kidnapped. We've seen that. They're kidnapped by Boko Haram. Over the last 2 years, they have kidnapped around 2,000 girls, and they force them to marry their kidnappers. And if they don't want to, they use them as child bombs in their wars. In Argentina, we have a woman who dies as a result of femicide each day. In Russia, 2 years ago, they only just decriminalized domestic violence because they say that nobody has the right to interfere in domestic matters. It's a family issue. So a woman in Russia cannot report if she is beaten by her husband because that's not a crime. It's not a crime. It's not considered a crime if it's a domestic violence. In the United States, an Argentinian economist, Mercedes Alexander, who lives in New York, she's a missionary. She wrote a book, which was published recently. She says that in 2015, documents were leaked from Sony that showed that Jennifer Lawrence, the star from the Hunger Games, one of the richest women in the world, had received several $1 million less in payment in her last film compared to her male colleagues. Patricia Arquette, when she got her Oscar, she said now is the time to have equal salaries once and for all and equal rights for women in the United States. In 2017, Robin Wright from the House of Cards demanded that Netflix paid her the same as Kevin Spacey. These demands have helped to make the public aware of what is happening in the first world countries. So this inequality, this abuse, harassment, this is happening in all of the cities around the world. And according to the International Labour Organization, to revert this situation, we're going to need 217 years. Well, so you can get an idea just how much work the IAWGA really needs to do. I shall finish with that. We believe in justice as a value and a service. Those of us that belong to the International Association of Women Judges, we feel proud to be judges serving community. We want a plural, open society without stereotypes, without sexism. We want an inclusive society which respects the diversity and freedom of men and women equally. We believe in the associative movement with a gender perspective. We defend judicial associations working within the gender perspective. Brothers and sisters under the law, it's all about living according to a new ethical idea of justice, which goes beyond formal patriarchal justice, which has been proven to be insufficient to meet the demands of people, above all the most vulnerable, and above all women, girls, and elderly ladies. Thank you.
Me comenta Susana que tiene un pequeño.
Susanna tells me she has a short video. I think we will no doubt maybe find a better moment to watch this with plenty of time. The organisers have told me that we're going to have a short debate. I don't know whether all of the participants in the conference understand that the Women's Institute are going to invite all of us to have some lunch. So on the third floor, we have lunch, light lunch. So we do need to respect the timetables. We need to be punctual. We will have a chance to talk as we eat. But if there are any questions right now, we're going to go for lunch. They've told 2:30 for lunch on the third floor, no later than 2:30, I've been told. Sorry? And we'll be coming back at 3:30. 3:30, we all have to be back here. Just one moment. Sorry. I would just ask for any questions to be short and for answers to be short, so we have time to do a few at least.
بسم الله. أحب أن أضيف إلى ما ذكرته السيدة سوزانا أن في.
With regards what Susanna has said, if we talk about Libya and the Islamic groups in Libya, they killed the lawyer and activist Salwa Bouages. They have murdered Fahiha Bakawi, a member of the parliament, and many women were murdered at the hands of Islamist groups such as Boko Haram, and all of the radicals in the western area are still pressuring the men and women in the prison. The government knows that. I just wanted to say that. Thank you. Any questions? Thank you. Good afternoon to everybody. My question is for the United Kingdom, Muriel Robinson. In Portugal, after the, well, given the representation of women in the judiciary system, I would like to talk about the possibility of introducing quotas for men, because there are so many women. I think this really goes against the idea of positive action. I would like you to talk about that, because what people say is that we have to have social representation amongst judges and magistrates. If we have 60% or more of women, then we need quotas for men. I would like to hear your view about that.
Yes. One of the valuable things about the way that positive action laws are represented is that they talk about underrepresentation. And so it would work both ways potentially then. If there's underrepresentation of men, then positive action initiatives would be permitted in order to reach a more balanced position. So that usually initiatives will have what get called a sunset clause. In other words, that be time limited with a view to reaching a particular position. So very often then, if that 60-40 or 50-50 has been reached, then the law would no longer operate. So there are a number of ways that that concern that you have can be addressed.
The organisers tell me that we can't continue with any further questions. I'm sure Maria Emilia will be delighted to answer questions individually, but I am really being told they're insisting that we cannot continue any further. I'm very sorry. But we're all going to be having lunch up on the 3rd floor. You can ask any questions you have then. Thank you very much.